record. Okay, we're on the record calling docket number 21-UST-EA-02, Department of Health of the State of Hawaii versus Respondent, United States Department of the Navy. This is a continued evidentiary hearing on the merits and closing arguments. May I please have appearances of counsel? Let's go in order. Mr. Hargrove.
Good morning. This is Wade Hargrove, Deputy Attorney General for the Department of Health.
Good morning. Ms. Gannon.
Good morning, Hearing Officer Day and Counsel. My name is Ella Foley-Gannon. I'm with Morgan, Lewis & Bacchius. I have my colleague here, David Brown, also of Morgan Lewis, and Jeff Lau of the City and County of Honolulu. Also in the room with us here physically is Uge Moman, also from Morgan Lewis, and we represent the Board of Water Supply.
Thank you very much. Now, Mr. Henkin.
Good morning. My name is David Henkin. I'm an attorney with Earth Justice, and we represent Sierra Club.
And I did forget to mention that Erwin Kawada, our client representative of the BWS, is also in the room.
The figurative room.
The virtual room, right.
Mr. Jensen.
Good morning. My name is Craig Jensen. With me in the room is Dave Fitzpatrick, and with us virtually are Marnie Riddle and John McKay, and we represent the Department of the Navy in this matter. Thank you.
Okay, we're going to do just the final housekeeping matters regarding exhibits. Since yesterday, I believe now, we have exhibits filed that were supplements to the record. One from Sierra Club, that was exhibits. Let's see here. Just say it for the record. Exhibit S30 or S40. We had, and that's been uploaded to the database with an amended exhibit list. We have with BWS, let's see here. So 4 exhibits, and this would be, I believe, you correct me if I'm wrong, this is B422, B423, B424, and what is the fourth one?
B361.
B361. And these have been uploaded into the database?
That's correct.
Okay, and we have an amended, updated exhibit list. And then just before we got on, we received an amended exhibit list from the Navy with exhibit N-7N added to the record. And I believe that has been uploaded, correct?
That is correct.
Okay. Is there any other exhibit that needs to be added this time besides the motion to admit exhibits that we had, that was just filed this morning?
Not from the board.
Not from Sierra Club. I should mention that Sierra Club representative Wayne Tanaka has just entered the virtual room.
Okay. Thank you. Welcome. Welcome, Mr. Tanaka. Okay. Seeing none, let's just move on quickly to the motion to admit exhibits that was filed this morning by the Navy. This is exhibits N-70 and N-7P. This is a request to supplement. I'll just go around. Mr. Hargrove, any objection?
No objection. Thank you.
Ms. Gannon?
No objection.
Mr. Henkin?
We're deeply concerned that we did not have the opportunity to see these exhibits during yesterday's proceedings, that we were deprived of the opportunity to cross-examine. Just wanted to say that for the record. Our position is that the truth is on our side in this proceeding, and so if these are materials that the Navy wants to present, then we have no objection. So
noted. Without objection, these are admitted into evidence. This is exhibits N-70 and N-7P. The Navy can, oh, pardon me, Mr. Oh, Mr. Jensen, do you have something to say? I'm sorry.
Yes, I'd just like to proffer for the record and the viewing public that these two exhibits consist of a media release from the Department of the Navy dated November 29th, 2021, informing the public of the groundwater contaminant or of the potential for water contamination in the drinking water, and subsequently a newspaper article or an article from the Hawaii Public Radio's website dated November 30th, advising the public also with regard to this media release. And it goes to counter the claim that the Navy did not notify the public with regard to the contamination issue until the 3rd of December. Thank you.
With due respect, that's a mischaracterization of the media release. The media release states that guidance for only residents of the Joint Base Pearl Harbor Hickam military housing, so not AMR or anyone else, those people were advised by the Navy that if they smell fuel in their water, maybe you don't want to ingest it. That's N-7O. So no, it's not a general notification of the public. It's not a statement that things aren't safe to drink. It's if you smell fuel, don't drink it if you live at Joint Base Pearl Harbor Hickam. N-7P is a news report that accurately says that the Navy made that recommendation. It says U.S. Navy recommended Monday night that Joint Base Pearl Harbor Hickam military housing residents avoid ingestion of their potable water as a cautionary measure, quote, if chemical or petroleum odors are present, end quote. The news report is also accurate, saying, quote, the State Department of Health went a step further Monday and recommended that all, underscore all, Navy water system users avoid using the water for drinking, cooking, or oral hygiene. That is not with respect to if you smell anything, because if you smell anything, they also said, if you detect a fuel odor from your water, you should avoid using the water for drinking, cooking, bathing, dishwashing, laundry, or oral hygiene. That's what the Department of Health said. And it also correctly notes that the commander of Joint Base Pearl Harbor Hickam sent a message to residents in the military housing communities on Monday, reaffirming their commitment to investigating the complaints. And then Captain Eric Spitzer said that he and his staff were drinking the water. Some staff members also live in the housing and were using the water as well. So that's the information that the Navy provided to the public on the 29th, which is we're drinking it. If you smell fuel, don't drink it. Or think about not drinking it.
If I can,
Yeah, of course, Mr. Jensen. So but after Mr. Jensen, after you comment, we're just going to close it right there. Mr. Jensen, you may respond.
I would just like to point out that with regard to the newspaper article, the Navy has no control over what the news system publishes. The important point is with regard to our media release, and our media release says, not maybe, as Mr. Henkin would claim, it does say in particular, if chemical or petroleum odors are present, recommend avoiding ingestion as a cautionary measure. Thank you.
And apparently you have no control over the commander of Joint Base Pearl Harbor Hickam telling people, I'm drinking it, don't worry about it.
I'm out. That's it. Okay. We'll save this for argument. The documents speak for themselves and you can argue it at the appropriate time.
The public probably won't have access to these documents. And so Mr. Jensen wanted to put on the record what they said, and so did I.
Okay. I believe that's been done.
Thank you.
So with respect to just confirm on the record, N-7O and N-7P are admitted into evidence without objection. Those can be uploaded immediately and an amended exhibit list filed. With that understanding, I believe that is the close of all pending requests. Mr. Hargrove, would you like to add anything before we close the trial record?
Would not, thank you.
Ms. Gannon,
Nothing further to add.
Mr. Henkin,
Nothing further.
Mr. Jensen.
Nothing further.
With that, the trial record will be closed. As soon as Mr. Jensen informs us that the documents have been uploaded, I will work with our DOH staff to basically close the joint database that we've been using so that it's not subject to amendment anymore. And then we will proceed. With respect to the arguments today, we have
one question. Sorry, here, just a technical issue. Will the parties still be able to access it to
Oh, yes.
download?
Yeah, so basically it'll just prohibit uploading.
Wonderful. Thank you very much.
With respect to today, we have 15 minutes apiece for closing arguments. The order of presentation is the reverse order of the evidentiary presentation from yesterday. That means it would be first the Navy, second Sierra Club, third Board of Water Supply, and fourth the Department of Health. I would like, if possible, just to make sure that the hearings officer has what I believe to be the correct framework of what is at issue in this case. I'll just briefly state my understanding of the issues, just basically the skeletal issues in this case. And you can tell me if I'm correct or incorrect, but I think that would be helpful to me in this argument. So basically, the hearings officer views the emergency order as borne out in the evidentiary hearing as having essentially two separate, albeit related emergencies. The first is the release on November 20th, 2021, and the ongoing response. This concerns, in the emergency order, there are 5 enumerated orders, or I'll just call them the enumerated orders. This first emergency would concern 1, 2, and potentially 5. 1 concerns the immediate suspension of operations primarily. The second concerns the installation of a drinking water treatment system or systems. And then the fifth is basically about taking corrective actions. The second alleged emergency is broader and concerns the systemic problems with the continuing operation of the Red Hill bulk fuel storage tank at the current time at any fashion. And this is all 20 tanks. And this primarily concerns emergency orders enumerated as 3 and 4, which primarily concern the defueling of 20 bulk fuel storage tanks. And again, order 5 could relate to both. The first emergency or the second alleged emergency. I believe that my take on it is they seem to be separate but related. I would like a statement from each party whether they agree with that characterization or not. And with that, Mr. Jensen, if you'd like to proceed.
Yes, sir. Good morning, hearing officer Day, council, and everyone watching. To a certain extent, the evidence presented and the arguments made by the 4 parties to this hearing are like 2 ships passing in the night. On the one hand, you have Department of Health, Board of Water Supply, and Sierra Club, and they're focused on the what if this and what if that. And on the other hand, you have the Department of the Navy, and we're focused on what happened. How did the release happen? What did we do to isolate the contamination? What did we do to take care of our people? And what are we doing to clean up the mess? An emergency order must focus on what's happening now or just about to happen. What is the imminent peril and how to handle it? Today, on December 21st, here is where we are. The emergency was realized. The Navy immediately responded by doing all things that you've heard. And because of that, there is nothing happening now or just about to happen that an emergency order needs to deal with. The last release from an underground storage tank was in 2014. And in 2015, the Department of Health, the EPA, the DLA, and the Navy mutually agreed on an AOC, an administrative order on consent, to address that release and to work cooperatively to protect drinking water, the human health, and the environment. The May and November releases were not from a tank farm, or were not from a tank. They were from pipes. And there is good cause to believe, as you heard yesterday, that the 2 releases are related, because the pipe in the November release was an AFFF pipe, a fire suppression pipe, which shouldn't have been holding fuel, had to have gotten the fuel from somewhere, and most probably got the fuel during the May release. That's under investigation, but that's what we know now. My point is that these releases, or indeed one release, the May release that ended up in the pipe and then subsequently was discharged from the pipe, the AFFF pipe, do not support a what if tank release. There are a lot of tools in the Department of Health's Board of Water Supplies and Sierra Club's toolbox to address the what if. The AOC is one, and the Department of Health agreed to it. Navy's role, as you've heard yesterday, is to produce deliverables. And we've done that. For example, the groundwater model was submitted in March of 2020. They've spent a year and a half talking about it and thinking about it. We've asked for formal comments on it, which they have not yet sent. They haven't engaged in the process they've agreed to. And now the Department of Health wants to use this process, the AOC itself, and their own dereliction within it as a basis for the emergency order. The permitting process is another regulatory tool, and Board of Water Supply, Sierra Club, and Department of Health, through the Environmental Health Agency, brought a contested case hearing over whether a permit should issue. The administrative order of consent is still in effect. It is working. Department of Health and the Navy remain engaged in that process, and 6 years later, there have been no further tank releases. The best evidence that our improvements are working. The permitting process is also still underway, and the Navy, Department of Health, Board of Water Supply, and Sierra Club are still very much engaged in it. Best evidence of that, the other three parties have moved to reopen the hearing to present the evidence that you heard yesterday, and undoubtedly a great deal more, given that that contested case hearing will not be confined to the one day that you had from the Department of Health to consider the matter. But let's take a moment and address the what if. Okay, let's talk about the what if. Red Hill, as you heard yesterday, the underground storage tank system has a series of interlocking safety systems to prevent releases, and if there is a release, to detect them. And that second part is important. Tank tightness testing, you heard about that. It's our leak detection method. We conduct it twice a year, even though the regulations only say we have to do it once a year. It takes days to conduct. It's performed by professional engineers, not the Navy, contracted professional engineers. And we've done it, and all active tanks have passed the tank tightness testing system. TERM is the Tank Inspection, Repair, and Maintenance Program. It's the industry standard approved by the American Petroleum Institute, and includes the non-destructive examination that you heard all about. It is also Department of Health approved. Automated fuel handling equipment. You heard about that from Captain Meyer. These are the fuel monitoring systems that gauge the fuel, work the processes. It works. It works in September in that incident that has been reported where there was no fuel release, but there was a problem with the system. It worked. Groundwater monitoring. You heard evidence on that, and you saw graphics on that. We prior to 2014 didn't have a lot of groundwater monitoring stations. We now have more than 20, and we're working to get more. Soil vapor monitoring. You heard about that too in the Department of Health testimony. They're early warning sentinels that something has gone wrong, that there's a problem in the tanks potentially, and that there's a leak. They're counters. These soil vapor monitoring systems are counters to any claim that a tank could be leaking a small amount and we would never know. And on these 5 systems, it's important for the hearing officer to understand, I think, that the only measure that's in the Department of Health underground storage tank regulations is the tank tightness testing measure. And that's once a year. The other systems, the other things I've just talked about, go above and beyond. Why does the Navy do it? Well, it's the right thing to do, obviously, but also because it was agreed to by Department of Health, EPA, and DLA. And it was designed to account for any special risk that might be present in the Red Hill underground storage tank system. So, and I'm going to get to your point now, sir, with regard to what does the emergency order offer and what should we, how should we think of it? Okay, we have an emergency order here. I'm going to talk about justification first, and then I'm going to talk about the directives. So we have an emergency order here without proper justification. First, the first justification cited to the emergency order are a number of alleged failings with regard to the AOC deliverables. We already talked about that. This justification is not in the form of an emergency, let alone imminent peril. There are disagreements on analysis, disagreements on experts, There's a resolution process in the AOC with regard to these disagreements on deliverables. The Department of Health has never exercised it. They can't, honestly, because they haven't even gone through the process of working it out with the Navy yet. We ask them for documents and they don't give it to us. So how can they move forward with their dispute resolution process there? That's one question, kind of irrelevant to this hearing. More relevant, how can they use that as a basis to claim that that is proper justification for an emergency order? It's just not. Second, the order lists what they allege are the 5 releases. The first, in 2014, as I already told you, was the impetus behind the AOC. A release in 2014 cannot justify an imminent peril determination in 2021, especially when the parties decided, including the EPA and DOH, decided that the proper vehicle to address that release is an administrative order and consent, which is what we all agreed to do. So that one's out. 2 additional releases, Hotel Pier and Kilo Pier. You didn't hear a lot about these, probably because all the parties recognize they're not really relevant, but I'll give you some information that you'll be able to see in the record and in our briefs, okay? First, they're pipe events. They're not tank events. Down at the harbor, 4 miles away, they're not up here, okay? And they're adjacent to surface waters, not the groundwater, all right? So those are important points. Plus, and significantly, those issues were both addressed on a practical and regulatory matter level. So they've been addressed, they've been resolved, and they were resolved consistent with what the regulators told us to do. So no one is at risk. And then finally, you have the May and November releases that are most probably connected, as I've already discussed. Importantly, the contamination source was isolated, people were protected, and cleanup is ongoing. Okay. So third, the order cites the contamination at Red Hill, suggests the contamination may have been a result of the May and November releases, and argues that Red Hill lacks infrastructure to deal with this. Okay, got that. We all agree, okay? There was probably a connection between the May and November release. And we have very good reason to think that the November release was the cause of the contamination to Red Hill. But the Red Hill shaft is closed down and will not reopen until water meets EPA and DOH requirements. Okay, that's important, number one. And on infrastructure, DOH wants drinking water treatment systems. The Navy wants drinking water treatment systems. We've already went out and purchased large GACs and are using them right now to clean out the distribution system of the Red Hill well. And we have even larger GACs, multi-million dollars, $20 million worth of GACs on their way that we're going to apply to the wellhead once we get a permit from Department of Health, because we would not do that without getting the permit from them, and use that to flush the water, okay, out of the well, treat it, okay, and put it back into the system. So those are the justifications. I just ran through all of them with you, and none of them support an emergency order. Let's talk about the directives. Directive 1. That the Navy immediately suspend operations at the bulk fuel storage tank. Well, as you know, the Navy's already suspended operations at Red Hill, and the Navy's suspension will continue at a minimum until the investigation into what happened at the Red Hill shaft and how it was contaminated is determined. And that makes sense, okay? A forever suspension is not appropriate. Find out what happened, you make sure the processes you have in place address it, and then you move forward. That's not what the emergency order does. But importantly, with the suspension, there is no emergent need to take any other action or to take another type of expansion to protect human health and the environment. Directive 2, that the Navy take immediate steps to install a drinking water system or systems at the Red Hill shaft. I've already talked about that, so I won't, we're doing it, all right? And that's important. Another important point is, just because a provision within the emergency order is a good idea doesn't mean that it substantiates or it validates the emergency order itself. Okay. And I think that's important. Directive 3, submit a work plan and implementation schedule to safely defuel the bulk fuel storage tanks. Well, the Navy's order says instead that the Navy will develop a work plan to conduct necessary repairs. Look, we have it right. Department of Health has the cart before the horse. They have it wrong. The Department of Health has presumed defueling is necessary and worked backwards to get to defueling. Okay. We instead are directing the same type of analysis be done. And however that analysis comes out, we will do the things required from that analysis. Secretary Balaki said on the stand yesterday, if that thing includes defueling one or more tanks, we will do it. So again, we're not putting the cart before the horse. We're working as we should chronologically moving forward. Directive 4, defuel the bulk fuel storage tanks at the facility. So again, the last release from an underground storage tank at Red Hill was in 2014. And we all know that it was caused by contractor error. The Navy has a robust program to ensure that the continuation of the integrity of the tanks. The recent releases, the ones that everyone complains about, are from pipes, not tanks. And one of them was from an AFFF pipe, which isn't even a fuel pipe. Assuming there is imminent peril, therefore, which there is not, an appropriate order would address deficiencies in the pipes, not the tanks. Directive 4. I'm sorry, I just discussed Directive 4. Directive 5. Submit a work plan to determine deficiencies that may impact the environment and develop correct recommendations for corrective action. The SECNAV memo contains nearly identical language. And again, I'll make the point. The mere fact that some of the emergency orders provisions are good ideas is not the legal standard for whether an emergency order is appropriate. The stakes are high. Secretary Balaki has told you that the Red Hill bulk fuel storage facility is a critical national security asset. The burden is on the Department of Health, and they can't meet the emergency order standard. On the medical piece, you heard from Dr. McGinnis that based on what he knows, he does not anticipate any long-term health impacts. If that's not good enough for you, Dr. Felton, Department of Health's toxicologist, said the same thing. And she shared that both with you yesterday at the hearing and in public forum, at least 2 Fridays ago. And their opinion is based on medical and toxicological expertise and direct knowledge of both patient dose and exposure. And while Mr. Brown attempted to cross Dr. McGinnis with regard to textbooks, it's important to understand that he has the experience from the last 20 days, 25 days, to come and the expertise to come to his opinion. And I would note that Mr. Brown did not choose to cross-examine Dr. Felton with regard to her position. The Navy has isolated the Red Hill shaft and suspended operations at the underground storage tank facility and is taking
15 minutes has elapsed.
You may sum up.
Okay. It's taking care of people in extraordinary ways. The Navy is testing constantly and continues to confirm that the only well impacted is the Red Hill well. In addition, we're purchasing clean water or drinking water systems, treatment systems. Yes, pumping draws contamination to the wellhead. Sherry Ng told you that yesterday on Direct. And that's why we have 2 larger GAC systems, which are expected to be here within roughly 2 weeks, and for which we're seeking a permit from Department of Health that will flush and treat the Red Hill. That is so important. Once again, the Navy is not saying that the contamination at the Red Hill shaft was not significant. It was. And the Navy and I personally am deeply, deeply sorry for the impact of that contamination on the lives and the people of Oahu. What we are saying is that our efforts to address this issue have mitigated the immediate impacts and kept any further significant impacts from happening. No one is at actual risk of harm today, and there is no justification for any provision of this order. Subject to your question, sir. Thank you very much. Thank you very much.
Very much. For everybody else's knowledge, the same ability to summate their argument that was granted to Mr. Jensen will be granted to everybody else as well, in like form. Mr. Henkin.
Good morning, Hearing Officer Day, Council, members of the public. Sierra Club is shocked at the Navy trying to lay the blame for its own leaks and spills that have poisoned our water supply, trying to lay that on the Department of Health. Sierra Club intervened in this case because we were concerned that the Department of Health might not stick to its guns as far as implementing the emergency order. But we have never suggested that the responsibility for keeping fuel in the tanks, fuel in the pipes, lies squarely on the Navy. So I don't know. I did not expect to hear that. In response, hearings officer, to your initial question, we agree completely with your characterization of the two different elements of the emergency order. You've got a question whether there was an emergency on November 20th when 14,000 gallons of mixed fuel and water entered the drinking water system of the Navy, poisoning the well literally for nearly 100,000 military service members and their families. And, you know, all of the evidence we've heard from everyone who wasn't coached by counsel admitted that it was a crisis. That was, we heard from Captain McGinnis that it was a public health crisis. We heard from Captain Meyer that it was a crisis. We heard, you know, so there's no question but that emergency exists. And with respect to those particular provisions, provisions 1, 2, and 5 of the emergency order, the Navy basically has conceded that there was an emergency. These things needed to be done. And I'll get into this a little bit later, but rather than abide by the December 6, 2021 emergency order and not contest at least those provisions, the Navy decided to contest it. And then the Secretary of the Navy decided to issue his own order the next day on December the 7th, and that's Exhibit N-1C, and say, we're going to do all those things. And now Mr. Jensen and the Navy tell you, because we're doing those things, there's no longer an emergency. They should have just abided by the order. But, you know, ultimately, you know, the other issue that came up and what the Navy had to say is, Mr. Jensen kept saying, it's not the tanks, it's the pipes. Well, first of all, the emergency order under HRS 342L has to do with the entire underground storage tank system, the entire facility, not just the tanks, but also the pipes. It provides cold comfort to the public that the Navy apparently doesn't even know where the 14,000 gallons of fuel really came from. They suspect that it came from the from the May 6th release. Now, remember, back in May 6th and following, they did an investigation. They determined there was a release of 1,600 gallons. They claimed to have accounted for all but 38 of those gallons. They went through that investigation. Now, if Mr. Jensen was correct that they have systems in place to make sure that they can prevent leaks, and then when leaks happen, respond to them properly, this is a vivid illustration that you know, this archaic system that they're trying to operate with over 180 million gallons of fuel perched 100 feet over our sole source aquifer and threatening, you know, catastrophe on the scale of what happened on November the 20th, and frankly, even worse things that in the future. The fact that it came from a pipe and it came from an AFFF pipe, which is not even supposed to have fuel, that doesn't give me, and it shouldn't give you, and it shouldn't give the public any comfort. If they don't know where the fuel is coming from and where it's going to, and we heard from Captain Meyer that maybe there was a release on May the 6th, not of 1,600 gallons, but maybe it was closer to 19,000 gallons. You know, this is the existential threat that we face. And so, you know, really ultimately what this case is going to turn on is whether the existential threat to the people of this island posed by the Red Hill facility, not necessarily by individual tanks, but the entire operation, which under the law is regulated as one entity, constitutes an emergency justifying the department's exercise of its, quote, emergency powers, end quote. And I use that term specifically because that is the language of HRS 342L9A, the legislature said these are emergency powers. It defined what an emergency is by saying that these are the powers that you can exercise when the terms of HRS 342L9A apply. So the question is whether this department, the Department of Health, can use these emergency powers to protect the people's constitutional right to a clean and healthy environment and to discharge its duty to protect Oahu's sole source aquifer, which is an irreplaceable public trust resource. Now, there's no issue about the fact this is a federal facility or a military facility or anything like that, because in enacting the Resource Conservation Recovery Act, the federal government expressly waived its sovereign immunity and made all of its facilities, including Red Hill, subject to state regulation of its underground tanks. And again, not just the individual tanks, but the entire system, including these pipes that AFFF pipes and any other pipes that are going to leak oil into the environment, including the ones down by the water, because the water, even though that didn't get into the aquifer, that poisoned Pearl Harbor, which is also a public trust resource. So again, in terms of the department's obligation to protect our ocean, as well as our groundwater, the fact that there have been four releases in this year alone, the May 6th release and the Kilo and Hotel Pier releases, and then this November 20 disaster, res ipsa, the facts speak for themselves. The Navy has absolutely no control over protecting the environment from being poisoned and protecting the people of this island from being poisoned. So despite all of this, the Navy tries to avoid its statutory duties, as well as its moral obligation to the people it has sworn to defend against enemies foreign and domestic by trying to exploit perceived legal loopholes. It says that 342L9 does not apply because there is no imminent peril. And it says even if it does apply, the department can't use its statutory authority that the legislature expressly gave it to protect us because the department allegedly tied its own hands in the AOC and is obliged to slog through years of negotiation with the Navy, which, as we well know, the Navy will never agree to do anything that anyone else tells it to do. Witness that they are objecting to paragraphs 1, 2, and 5 of the the emergency order because they didn't say so, but then the next day the Secretary of the Navy ordered it, and now they say it's the thing to do. Footnote: the Secretary of the Navy issued that order on December the 7th, and the terms of the order claim that they're going to keep the Red Hill tanks inoperable until they finish their investigation. However, as Secretary Balaki testified last night, tomorrow the Secretary, or later today, the Secretary could rescind his own order because they want to be in control. They want to decide what they do and when they do it. They don't want the Department of Health, which is the entity that is to protect us and protect our environment, to be in control. Fortunately, none of this is accurate from a legal standpoint, or I might say from a moral standpoint. So first of all, with respect to whether or not there is 342L9 applies, I discussed this in my opening. The statute defines the trigger. What the legislature said is whether the operation of the facility poses, whether it poses imminent peril now or in the future. And the thing that needs to be imminent is peril, risk. It doesn't have to be actuality. You don't need to wait until the oil is poisoning the water to act. In fact, consistent with the precautionary principle and its constitutional duty to protect the public trust, the department has to act now. You can't wait. We heard from Captain Meyer. I asked him, I said, why didn't you stop the May 6th release of whether it's 1,600 or 19,000 gallons? He said, well, we couldn't do that. And now, why didn't they stop the 14,000 gallons from poisoning their own water system? Because they can't. Under their definition of what an imminent peril is, you have to wait till, to use Mr. Jensen's term, the horse is out of the barn. I'm sorry, the horse got off the cart and now it's out of the barn. And try and close the barn horse doors after you've already poisoned the water. That's not what the legislature intended. The legislature made it very clear that the department can and constitutionally must take action if there's imminent peril now or if there will be. So, and even if it, and so, it is undisputed in this case that the Red Hill facility stores over 180 million gallons of jet fuel in ancient tanks that loom a mere 100 feet above the aquifer that EPA has designated as the sole source aquifer for this island. It's undisputed that these tanks and the pipes and the whole facility leaks, and it has poisoned the environment, most notably on November the 20th, but it's done it before. There's all sorts of contaminants in the groundwater, and there's a lot of uncertainty about where things end up. Again, witness the May 6th event, in which we don't really know where the fuel went, how much fuel there was, and now we suspect, because the Navy has no other way to account for 14,000 gallons of fuel somehow entering its water supply system. They say, oh, it must be the May the 6th event, but they don't know. I mean, that's why I was trying to explore that with Captain Meyer. I said, you said there's no connection between what happened on May 6th and the AFFF pipe. And he's like, where else would it come from? Good question. Talk about imminent peril. Talk about a facility that needs to be defueled, not forever, as Mr. Jensen would suggest, but as the emergency order very properly says, it needs to be defueled now because it poses an imminent threat, and it can be refueled when it's safe to do so, Now, Mr. Jensen sort of walked through these various releases. Oh, there was a 2014 and that got resolved. And then you had all these other releases, the May 6th and the Kilo Pier and the November 20th, and we're dealing with it. What the Navy fails to recognize is that the regulation is not of individual releases. That is one thing that can trigger an emergency order, but it's a regulation of the operation of a facility that poses an imminent peril. And there is no dispute here, there should be no dispute, that this facility poses an imminent peril. You have the unrebutted testimony of Professor Lawrence Thomas Ramsey, who described the chilling implications of the aptly named Russian roulette analysis in the Navy's own QRVA. So that document's S26. And that's the one that tells you that the likelihood of a leak of 1,000 to 3,000 or 30,000 gallons in any given year is nearly 28%. In 5 years is over 80%. And in 10 years is 96%. And in 20 years is a near certainty at 99.8%. You have the testimony of Dr. David Norfleet that the Navy's analysis underestimates the risk. It failed to take things into account. And it is undisputed that it's only the first of 4 analyses, because they didn't consider, for example, risk from earthquake, fire, or flooding. The initial analyses will only increase the risk, not decrease the risk. Now, the Navy offered no new expert analysis that takes into account the recent leaks, including the November 20 event. Instead, its lawyers baldly assert the Navy's reduced risk by identifying unspecified measures since they did their risk analysis in 2018. Lawyer statements are no substitute for evidence. In any event, it ignores the facts on the ground. We've had 2 releases of more than 1,000 gallons related to operations at Red Hill in this year alone. The May 6 one of 1,600 gallons, although the working assumption is now that it might have been 19,000 gallons, and the catastrophic release of 14,000 gallons on November 20. That's 2 in 1 year, not 1 every 20 years. So the risk analysis, if anything, underestimates the threat. I'm going to get back to a point I made at the beginning. This is clearly a power struggle. It's a power struggle between the Navy and the Department of Health. The Navy wants to arrogate to itself the sole authority to decide how much protection we can get from being poisoned by its wells. The Navy acknowledged that an emergency existed that necessitated shutting down the Red Hill shaft, that necessitated bringing in these GACs and things to clean out the water system. And well, it should. You heard the chilling testimony from our witnesses who have suffered through the nightmare of the Navy's disaster. But rather than acquiesce in at least those portions of the executive order, they decide to fight. And then they issue an order the next day, the Secretary of Navy's order, that he can rescind at any moment. But that, the evidence you've heard makes it clear that the things that they claim are simply not true. It's not, the nation will not fall if we defuel the Red Hill tanks. The order does not say that the fuel can't be anywhere. It just says it can't be in these leaking tanks over our aquifer. And Secretary Balaki said that if the Navy's analysis says that one or more fuels should be defueled, they're going to do it. Again, if they decide, they'll do it. But if the Department of Health, in the exercise of its constitutional and statutory duties, determines the safety of our people require it, they'll fight it to the death. The Navy's actions show that they're more concerned about whatever they consider to be their mission, and I would suggest it should be protecting our health and
15
safety.
minutes has elapsed.
Henkin, you may submit.
Thank you. The Navy has demonstrated through its actions that it will put whatever it considers to be its mission ahead of the interests of the people of Hawaii. It did not warn people after the spill on November 20th. Its belated, half-hearted, and misleading warnings after the Department of Health said don't drink the water, were only reported to the residents of Hick and Pearl Harbor and not the people at AMR who you've heard from who have been poisoned. And they only said don't drink it if you can't, if you smell the fuel, when we all know, and there's been testimony that still causes harm if you can't smell it. They violated the Department of Health's order. That's our exhibit S40. They decided, okay, we're going to open the fire hydrants and flush our system in violation of Department of Health orders. So they do whatever they want to do. Well, the Department of Health has a mission too. Its mission is to protect the people of Hawaii per statute and its constitutional duties. And so, you know, at the end of the day, their assurance is that they can protect us from a future spill, give cold comfort when you realize that they have no idea where the 14,000 gallons that poisoned the well on November 20th came from, even after months of investigating the May spill. They couldn't stop the prior releases. The statistical analysis and the risk assessment says it is not a question of whether, it is a question of when there will be another catastrophic spill. Captain Myers told us that it takes days, maybe over a week, to defuel a tank. They can't stop the harm from happening. We need to be proactive. We need to be precautionary. Make no mistake, imminent peril exists. It exists now. And the Department of Health should stick to its guns and hold the Navy to defueling those tanks and not allowing them to be refueled unless and until it is safe for the people of Hawaii. That's the department's obligation. We cannot defer that decision to the Navy as they argue. Thank you.
Thank you, Mr. Henkin.